16. Fundamentals of Arizona Anti-Deficiency Statutes. A few days later, Tom called Mark, sounding relieved. "I have some good news," he said. "My neighbor told me that because we live in Arizona, the bank can't ever come after us for the money we still owe." Mark paused before answering. "I've learned enough over the past few weeks not to answer questions like that without checking first." After the call, Mark walked directly into Lisa's office. "I think I know the answer," he said, "but I don't want to give legal advice." Lisa smiled. "Good. That's exactly the right response." She motioned for Mark to sit down. Arizona's anti-deficiency statutes are some of the most misunderstood laws in real estate. Many homeowners hear bits and pieces of information from neighbors, family members, or the internet, and assume they apply to every situation. They don't. Lisa walked over to the whiteboard and wrote two statute numbers. ARS, Section 33-729. ARS, Section 33-814. These are Arizona's anti-deficiency statutes, she explained. They were created to protect certain homeowners after qualifying foreclosure sales by limiting when a lender may pursue the borrower for a remaining loan balance. Mark immediately asked, "So they automatically protect everyone completing a short sale?" Lisa shook her head. "That's one of the biggest misconceptions." She explained that whether anti-deficiency protections apply depends on several factors, including the type of loan, the property, how the loan was originated, and the facts surrounding the transaction. That's why we never tell a seller they're automatically protected. We encourage them to speak with an Arizona real estate attorney before making decisions that could affect their legal rights. Mark nodded. "So our job is to recognize the issue, not interpret the law." "Exactly," Lisa continued. "In many short sales, the lender's approval letter becomes one of the most important documents in the transaction." She explained that the approval letter should clearly state whether the lender is accepting the short sale proceeds as full satisfaction of the debt, or whether the lender is requiring additional payments, a promissory note, or other conditions before releasing the borrower. Never assume that lender approval automatically means the remaining debt has been forgiven. Read the approval letter carefully. If there's any uncertainty, recommend that your client have it reviewed by legal counsel. Mark looked back at Tom's file. "What types of properties are most commonly associated with Arizona's anti-deficiency protections?" Lisa explained that the statutes generally apply only under specific circumstances and that qualification depends upon the facts of each transaction. Factors that may affect whether the protections apply include whether the loan is a purchase money obligation, the type and use of the property, the manner in which the lender enforces its remedies. "Those aren't decisions we make as real estate professionals," Lisa reminded him. "They're legal questions." She continued, "Another issue many homeowners overlook involves second mortgages and home equity lines of credit." Mark nodded. "I was wondering about that." Lisa explained that multiple loans often mean multiple negotiations. The first lender may approve the short sale. The second lender may also have to agree. Each lien holder may have different requirements before releasing its lien. She reminded Mark that every lien should be addressed before closing, and that the settlement statement and lender approval letter should be reviewed carefully to ensure all negotiated terms are reflected. Mark smiled. "So even though the purchase contract is between the buyer and seller, there can be several lenders making decisions." "Exactly. That's one reason short sales require so much coordination." Lisa paused before offering another important reminder. "Homeowners also need to understand there may be tax consequences associated with debt forgiveness." She quickly added, "But that's another area where we stay within the scope of our real estate license. We encourage clients to consult qualified tax professionals rather than offering tax advice ourselves." Mark leaned back in his chair. "I think I'm starting to notice a pattern." Lisa laughed. "What pattern?" "The more complicated the legal question becomes, the more important it is for us to know where our role ends." Lisa smiled. "That's one of the most valuable lessons you'll ever learn. Protecting the public doesn't mean having every answer. It means recognizing issues, educating your clients about the transaction, providing the required disclosures, and directing them to qualified professionals when legal or tax advice is needed." She closed Tom's file. "Now that we've discussed Arizona's anti-deficiency laws, it's time to shift our focus to another important part of every short sale. We need to understand the disclosure requirements that protect buyers, sellers, and real estate professionals throughout the transaction." Key takeaways. Arizona's anti-deficiency statutes provide important legal protections in certain situations, but they do not automatically apply to every short sale. Real estate professionals should never assume the seller is protected from future liability without reviewing the lender's approval terms and encouraging the seller to obtain legal advice. Multiple loans or lien holders may require separate negotiations and approvals before a short sale can close. Questions involving deficiency liability and debt forgiveness should be referred to qualified legal and tax professionals. Arizona licensees protect the public by remaining within the scope of their real estate license while educating clients throughout the transaction. Online discussion question 1. Why should Arizona real estate professionals avoid telling sellers that they are automatically protected by the anti-deficiency statutes? Answer. Whether Arizona's anti-deficiency statutes apply depends on the specific facts of the transaction, the loan, and the property. These are legal determinations that should be made by qualified legal counsel rather than a real estate licensee. Question 2. Why is the lender's short sale approval letter so important? Answer. The approval letter outlines the lender's conditions for approving the short sale and may address issues such as deficiency liability, financial contributions, promissory notes, or other obligations. Sellers should carefully review the document with legal counsel if questions arise. Question 3. How can Arizona real estate professionals protect both their clients and their licenses when legal questions arise? Answer. Licensees should educate clients about the transaction, provide required disclosures, remain within the scope of their license, and recommend that clients consult qualified legal and tax professionals for advice regarding legal rights or tax consequences.